has a full turnout. Item 1 today is to continue consideration to take oral evidence on the Legal Services Scotland Bill. Can I welcome the first panel of witnesses, who are Ian Smart, President, Lorna Jack, Chief Executive, Michael Clancy, Director of Law Reform, and Katie Hay, Law Reform Officer, all of the Law Society of Scotland. I take it, Mr Smart, you will be lead witness in this case, and if I ask the questions to you and other members ask questions, you can allocate the question to the appropriate officer who is with you. So I will open the questioning by asking you, Mr Smart, is the Society convinced that the bill is necessary and that the establishment of alternative business structures will benefit users of legal services in Scotland as well as practitioners?
The short answer to your question is yes. The bill implements in large part the adopted policy of the Law Society that we adopted at our annual general meeting in May 2008. There are a number of reasons that we support this legislation. The first is simply that the structure of the legal profession is changing. The kind of conventional view of a solicitor in Scotland as somebody in a relatively small, modest partnership of 3 or 4 other solicitors based in a county town. But actually, if you look at the current demographic of the profession, it is very far from that. 3/4 of all solicitors now are employed in one capacity or other, some by the state, local or national, and others by the private sector directly, but a good number of them actually employed solicitors. And the old partnership model is one which is in steady decline. In practice, the Society has already allowed limited liability partnerships and since 1990 incorporated partnerships, and we see, incorporated practices. We simply see this as the next stage. It's clear that in some areas, I have to say, in our impression, more in relation to commercial users of legal services, there is also a demand for what's called a one-stop shop, where you can get more than one professional service provided under the one roof. There's been recent research, albeit south of the border, but involving a survey of the Scottish market itself by KPMG, that indicated that a very substantial 75% of commercial users of legal services welcomed that model. We looked into this. We did, frankly, at one point have some concerns about the ethical issues of that, but we think they have been worked through both in terms of our policy and how the government has implemented that policy in terms of the bill. And we see no reason that this can't simply be the next stage in modernisation of the provision of legal services to the public.
Thank you. Can you remind us, for the record, how many members you have?
We have approximately 10,500 members.
Yes. Are there differences of view between the membership as to the way forward?
We wouldn't be kidding you that there isn't a division of opinion. We can only say that at the annual general meeting, which voted on this matter, that it was by a margin of more than 4-1 to endorse the principle of alternative business structures. We have some reservations on the technicalities of this particular bill, which we will be happy to go into as the questioning develops. But our view is that whilst there is a legitimate and perfectly respectable minority opinion, which is opposed to the principle, particularly of external ownership of legal businesses, all of the evidence suggests that it is a minority opinion.
Heard the evidence of Professor Alan Patterson last week, who seemed to indicate that the proposals here were being driven by the larger partnerships. Any comment on that?
First of all, the larger partnerships are a very, very important part of the Scottish legal services market. You can't lose sight of that. It would be fair to say that I think that the larger firms are the ones who see themselves most immediately in a position to take advantage of this change. But there are circumstances in which smaller firms might do so. One of the things that's changed in the legal market in my time was that client-facing services were in the past overwhelmingly, almost universally provided by solicitors. Increasingly now, in certain areas of the market, paralegals play a very important part. It's not possible, as matters presently stand, for paralegals to be part owners of businesses. You can't have an employee share ownership scheme in the legal business in the way that you can in just about any other business. And we think that's something that small firms are likely to take up.
Bill Butler and Robert.
Just a question of fact, because I'm inquisitive, Mr Smart, what percentage of votes at the annual general meeting of the Law Society are exercised, or cast rather, by larger partnerships?
In terms of the very broad breakdown of the profession, it breaks down in very, very round figures. 1/3 in-house solicitors, that's people who work directly for central government, local government, Standard Life, the Royal Bank, all the other major corporate institutions in Scotland. 1/3 of solicitors work in the traditional high street model, either as partners or as employees in that model, and 1/3 belong to the big firms. And we define for that purpose firms with more than 20 partners.
Yeah, that's handy, because it wasn't quite the question I asked you. It's 1/3, 1/3, 1/3 in the division in terms of the different types. But what percentage of votes, for example, is it 1/3, 1/3, 1/3 in terms of the votes exercised at AGMs by, let's say, big firms, or do they have a larger percentage? That was the question.
No, it's one solicitor, one vote that operates. We have a system where there is proxy voting, so you can appoint someone to cast a vote on your behalf. I might say the President of the Law Society commonly has the largest number of proxy votes at general meetings. It's inclined to be what's on the agenda. When we had a special general meeting within the last year on the question of criminal legal aid fees, and almost all of the votes at that meeting were cast by criminal legal aid lawyers. There was effectively no participation by the bigger firms. It's inclined to be whatever's on the agenda is of interest to the particular interest group within the profession. They're inclined to be more represented. Similarly, Mr Maxwell will know that the issue of home reports was a very controversial one, and on that we had a huge number of votes cast, largely by proxy, but it largely came from those solicitors who were involved in domestic conveyancing, because they were the ones with a direct interest.
Thanks for that answer. One last question, if I may. In terms of the third of votes, one solicitor, one vote, very democratic, and I agree with that. But in terms of the votes cast by the more traditional, smaller partnerships, do you have a breakdown as to how, what percentage of that third voted for this bill in principle, and what percentage was against?
To be honest, I don't think it's possible really to give you that breakdown in terms of, we can tell you that there were approximately 1,000 votes cast at the AGM on the matter, and that the margin was more than 4-1. But did we do any analysis of how the minority was made up, or indeed how the majority was made up? No, we didn't.
That's a pity, but thanks for that.
Thank you, Robert Brown.
Can I just pursue that a little bit in terms of proxy votes at the AGM that considered, the principles of the bill, or the principles that led to the bill? Can you give us any indication of the number of proxy votes at that meeting?
The voting at the meeting was 801 to 132. I think in the actual AGM we have what the show of hands was, which would give you. If you give me just a moment, I'll try and find that reference.
Meantime, can I add a comment to that? The other thing about the bill, of course, is that it's not mandatory, and so it's a permissive bill, obviously, that will allow new structures but won't stop the traditional part of the profession, particularly those in private practice, to remain structured as is. It's very much that we're in favour of.
But the figures, Mr Smart.
I do. On a show of hands, the vote was 49-18. So that gives you some indication of the people who were personally present. And on a proxy vote, it was 801 to 132. So there were probably 10 times as many proxy votes cast as people who were actually present at the meeting. I have to say that's in accordance with quite often the situation at such meetings, because they do take place during the working day, and people are all working lawyers, and the ability to take time out of the office to come to the meeting, they're inclined to entrust their vote to somebody who they know.
Yes, I mean, the purpose of my question, really, I think of Mr Butler's questions too, was that you indicated that at criminal legal aid issues, there was usually criminal lawyers were the ones that voted. Was that the case in terms of the big firms at the meeting that we're talking about?
I think I could say anecdotally, yes, that the big firms were the ones who were particularly animated to get this policy through. Just for the voice of any doubt, you're going to hear from the law agents this afternoon. No, they are probably the single most representative group of the high street firms. They have an ability, again, as Mr Maxwell knows from the experience of the home reports, they have the ability to organise very well if their membership are animated enough about the matter, and they chose not to organise in opposition to this policy.
No, I take that point, absolutely, but I mean, I suppose in a sense we wouldn't be pursuing these angles were it not for the fact